Hey everyone, I'm Amy Odom, and today I'll be discussing an ongoing case at the United States Supreme Court, Arellano versus McDonough. This case involves a veteran who had some pretty traumatic experiences while in service from 1977 to 1981. And as a result of these experiences, he developed some pretty severe PTS. His condition was so severe that um, he argues it made him unable to understand the process for applying for benefits when he first got out of service. So he didn't. And then 30 years later, with the help of his brother, he was able to put together a claim and file it with the VA for his psychiatric condition. His claim was immediately granted. He was service connected for PTS, and he was rated 100% disabling, which is indicative of a pretty severe psychiatric disability. You have to be completely disabled to get 100% rating. So VA granted service connection in the 100% rating effective 2011, which was the date that he filed the claim. He appealed that decision, requesting that VA give him the effective date of the day after his discharge. And his legal theory is this: there's a statute, 38 USC 5110, that sets forth the effective dates for service connection, pension, DIC, survivor's benefits. All of the effective dates are found in this statute. And the specific rule relating to service-connected disability compensation is found in subsection B, which says that if you file your claim within 1 year of discharge from service, the effective date of your benefits will be the day of discharge. Mr. Arellano has argued that he was so severely disabled during that first year and up until 30 years later when he filed his claim that he was unable to file, and therefore VA and the court should forgive that deadline, should extend that deadline for him. And the legal term for this is called equitable tolling. So his argument is that because he was so disabled that he was unable to file a claim within that first year and for the 30 years until 2011, that deadline, that 1 year deadline to get the date of discharge, should be equitably tolled until 2011 when he did finally get some help and file his claim. So the law on effective dates and equitable tolling, so this 1 year deadline, so far has been understood to mean that you cannot get equitable tolling for the deadline to file your claim, that it's not actually what we call a statute of limitations. And a statute of limitations sets a deadline for you generally to bring some sort of action. The Federal Circuit Court of Appeals held in a prior case that you could not get equitable tolling for that 1 year deadline to file your claim after discharge. But Mr. Arellano got some counsel and was able to challenge that holding from the Federal Circuit. Of course, the Veterans Court is bound by the Federal Circuit's holding, so they had to rule against Mr. Arellano. But when it got back up to the Federal Circuit, surprisingly, the court was split. It went to a full panel, what we call an en banc panel of the Federal Circuit, which means all of the judges on the court looked at this case. Half of them said, no, you can't get equitable tolling on that 1 year deadline. Our prior case law is correct. That's the end of it. Therefore, Mr. Arellano doesn't get equitable tolling. But the other half said, you can get equitable tolling for that 1 year deadline, just that Mr. Arellano doesn't get it because his specific circumstances, the disability making him unable to file a claim, does not qualify him for equitable tolling or extension of that deadline under this particular statute. And there's a whole statutory analysis rationale for why that's so. I'm not going to get into that now, but you can read that in the Arellano Federal Circuit split decision. So we had a we have a situation then where half the federal circuit says you can get equitable tolling under the statute 5110 with the effective dates for benefits, and another half saying no way, no how, no matter what the circumstances, just no equitable tolling for your effective date for benefits. So the Mr. Arellano appealed that decision up to the United States Supreme Court. The United States Supreme Court, it's very hard to get your case before them. You have to ask them to even hear the case. You file what's called a petition for certiorari, and very, very few petitions are granted a year. And this happened to be one of the few ones that the court granted last summer. Last year. So the parties have briefed the entire case, and there was an oral argument on October 4th, I believe, where Mr. Arellano's counsel made what I find to be pretty compelling argument as to why the Supreme Court should rule that equitable tolling does apply to the effective dates and the deadlines for filing claims to get the earliest possible effective date. And the government made its argument as to why it does not believe that equitable tolling should ever apply to the effective date provisions. So now we just have to wait and see what the Supreme Court says. I suspect that we will have a decision probably by this spring. We'll have something. And we'll probably do another video to get everybody up to speed on what that decision is then. But let's talk a little bit about what kind of effects this could have on veterans. Well, if Mr. Arellano loses, not much, right? Because it is the state of the law as it is anyway, is that you can't get equitable tolling for the deadlines on the effective dates. But if Mr. Arellano wins this case, it would have a pretty significant impact on veterans' disability law. It would mean that if you can prove that for some reason within that first year of discharge, you were unable to file a claim, either because of a significant disability, like Mr. Arellano claims, or because you were misled in some way by the government, or there was some other extraordinary circumstance out of your control that was during that first year and lasted until you were finally able to file a claim, then it's a potential that you could get an effective date back to the date of your discharge, even if it was 30 years ago, like Mr. Arellano. Some people are concerned that if the Supreme Court rules in Mr. Arellano's favor, there will be it will open up the floodgates, as they say, and thousands of vets will come with claims for earlier effective dates based on equitable tolling. The reality is it's still going to be really hard to prove entitlement to equitable tolling. Equitable tolling is the showing for equitable tolling is very high. It's very burdensome on the veteran. You have to show that if you had a disability, that it rendered you completely incapable of attending to your personal affairs during the period in time. In Mr. Arellano's case, that's 30 years. That's going to be a difficult showing. I'm not saying by any means that he can't make that showing, but it's especially since VA acknowledges that he's totally disabled, at least as of 2011. If he can show that he had that disability, that level of disability back to the date of discharge, then he's probably got a pretty good case for equitable tolling. But very few cases can actually, or very few claimants can actually make that showing. So will it open the floodgates? I don't think so. People may try, but it's, not everybody's going to get equitable tolling, and it'll still be a very difficult case to win. But it will be available, and it'll be a potential avenue of getting retroactive benefits for veterans who really were, for some extraordinary circumstance out of their control, unable to file their claim within that deadline. The other thing to keep in mind is that 1 year deadline for disability compensation, it doesn't mean that if you don't file your claim within the first year of discharge, you can't ever file a claim and get VA benefits. You can file the claim at any time, just like Mr. Arellano did 30 years after discharge. So this is really about whether you can get an extension to get retroactive benefits, whether you can apply equitable tolling to get retroactive benefits. So it's not going to affect veterans and claimants' ability to file claims and secure benefits going forward. It would just perhaps provide another avenue for claimants to recover retroactive benefits that they would have been entitled to had they filed the claim within that first year deadline. So that's Arellano. Thanks so much for joining me. I'm really looking forward to seeing what the Supreme Court has to say about this, and talking to you in the future about the results of this really exciting case. Please be sure to follow us on social media and subscribe to our channel for more videos. Thanks for tuning in.